Hello everybody and welcome back to Free Thought. Josh. It is around 4:30 p.m. Central Standard Time. We're recording to you live from Chicago, Illinois. I'm here with Vasily, who is one of my latest proteges, I guess if you're going to call him that. I'm teaching him about how to deal with judges, lawyers, cops. I'm trying to actually explain to him how to handle yourself, self-defense in a courtroom. And today he's going to talk to us about his experience today in criminal court. Go ahead and explain your background, how you got into this, and what's really going on. You asked some simple questions today, and they were not able to provide you with answers. Go ahead with that.
Well, my charge is I've been charged with possession of cannabis between 30 and 500 grams, and we are in the state of Illinois, where it is a felony to possess between 30 and 500 grams.
Class 4 felony.
It is a class 4 felony, which is the lightest felony, but it is still a felony, and it carries up to 3 years in prison. And I'm also on probation currently, which kind of complicates matters, aggravates it a little bit, I guess. But today was, I have been charged 2 weeks ago, and today was my first appearance, basically, which was a special appearance, meaning that I have initiated the contact, or I filed an affidavit which was drafted by Josh.
I wrote his affidavit, yes.
And it was filed last Friday, and I scheduled the appearance date myself.
Can you give me that affidavit, please?
And the special appearance also means that the judge does not have jurisdiction over you. When you appear on your own accord, he cannot throw you in jail.
Well, what's the bigger picture when it comes to their jurisdiction, though? What actually gives them jurisdiction in a courtroom?
Jurisdiction stems from evidence of the crime, from the crime that the prosecutor or the plaintiff claims that one has committed, or I have committed in this case.
Okay, and what makes a situation a crime?
It is. You can be charged with a crime only if you have, according to the common law, only if you have broken 5 basic rules or principles, which are violation of a contractual agreement, damage to the property, damage to the body, to the physical body, the human being, theft of the property, or death of the body. So if you violate any one of those
So
rules,
the basic, I guess you would call that necessarily the golden rules of stuff that you never want done to you, so why would you do it to someone else? You could basically say that. So, he went in, if you want to actually explain your case, and like when you went in, what did you say, what did you do, how did it escalate?
I went in this morning, and my last name starts with a B, therefore today at least they have proceeded alphabetically. Sometimes they do not. Sometimes
they don't.
Yeah, most of the time they don't. They just randomly go through a list of names. And today I happen to be lucky to be second or third to go up to the judge. And the first question was, "Where's your attorney?" And I have stated that I represent myself in the matter. After which, I've gotten a long speech on how it is unwise, in the opinion of the judge, for me to represent myself.
I'm gonna give you the collective story that he told me about how the judge treated that he wants to represent himself. He said, "Oh, you want to represent yourself? Okay. Well, if you need brain surgery, are you gonna try to give yourself brain surgery or something like that? Like, just because somebody is a professional at it doesn't mean they're going to do it to the ability that you're going to be able to do it." I'm not necessarily saying anyone should go out there and try to give themselves brain surgery, because that's obviously stupid. But in a courtroom, someone may know law better than you because they study it, they're licensed to do it, blah blah blah, that's their job. Does that mean that they have an obligation to treat you well with the stuff that they know? Absolutely not. So he was basically saying, I'm going to represent myself, I am going to present myself in this case, I'm the only one up here. and I'm going to handle my own business. Go ahead.
For which I got a lengthy response on how this is insane and how I'm strongly recommended to get an attorney.
Okay.
Then my charges have been read by the prosecutor, and my my actual charge have escalated. I have originally been charged with possession, and the prosecutor has switched it to possession with intent or manufacturing, which is which is
Intention to distribute.
yeah with yes possession with intention to distribute, which is a more serious charge and carries a higher penalty of up to 5 years in prison. And I'm not sure why this happened. Maybe they talked to each other and decided to charge me with because originally my charge was just possession.
Is it possible that they read the affidavits that we sent in and the motions to dismiss that we sent in, and they just said, "Oh, this guy's trying to have one over on us. Maybe we should hit him a little bit harder." Is that possible?
That's entirely possible. Then maybe they're just trying to scare me with a more serious charge, more time, more violence on their part,
Of course.
and trying to get me to go away and be just like everybody else, hide behind somebody,
Fear mongering, blah blah blah, all that fun
an
stuff.
attorney that is, who is a good friend of a judge or
They work for the
whatever.
same people. They're a fellow employee as a coworker. So I mean,
They're licensed by the state.
okay. So let's get more into the questions that you asked and what the result of those questions were.
Okay, so once I have established that I am representing myself, he asked me whether I understand the proceedings. I said no.
Never say that you understand anything.
You do not understand shit when it comes to talking to a magistrate or a judge, because understanding literally means that you are under their standing and you consent to their authority. So when you say I understand, yes, I understand, you basically are saying I consent to whatever you're trying to do to me.
See that's the whole legalese, whatever people call legalese.
Yes.
That's the whole law speak. That's their jargon for their job. When you hear the word understand, like if I were to say, "Oh man, do you understand what I'm saying?" You literally take it as you take it as do you comprehend? And that's a totally different thing in court. Yeah, what they're trying to say is, do you understand? Do you stand under our jurisdiction? Do you stand under our authority? It's a consensual thing that they're asking. So you said that you don't understand, and what happened after that?
I don't understand, and I asked whether I could have a few questions. Can I ask a few questions?
Okay.
And in response, I got some bullshit for a few moments, and eventually he said yes, because he cannot deny you, the judge cannot deny you the right to
Basically, they cannot continue or try to proceed if you don't even understand the nature of the charges. Yeah.
yes, whatever judge said. Yes.
Whatever.
So they cannot they cannot proceed without you knowing the proceedings. And my next question was whether I'm guaranteed responsive answers, and that question kind of started to piss off the judge a little bit. And again, he gave me a ramble about that I'm not really guaranteed anything. Eventually, he did say yes. My next question was whether I am guaranteed a fair and an impartial trial, and that question just set off the judge completely.
What did he do?
And after that he said I'm not guaranteed anything, and he wouldn't allow me to ask any more questions. And he told me that he's not gonna give me a civics class, which attorneys take in law school.
Just remember though, what he's saying is literally, he's asking a couple of questions, simple answers, yes or no. The first three are yes or no.
Yeah, so that was literally my third question. The first one was I can't ask the questions because I don't understand the proceedings. The second one was whether I'm going to get responsive answers to my questions, and the third one was whether I'm guaranteed a fair and an impartial trial. And by the third question, the judge wouldn't have any more of it, and he basically threatened to to uh,
Arrest you.
to arrest me,
Contempt, held in contempt. Yeah.
to hold me in contempt, and pointed to bailiffs towards me, and they did move towards me. They were standing on my side.
Mm. Is that an intimidation tactic, you think?
Most definitely, I
Okay.
was intimidated because I have
Obviously.
cuffs, and because I already have been violated before,
Mm-hmm.
and I've been taught to respect the authority from very very early age.
Yeah.
But anyways, she started yelling at me and told me to sit
Like a dog.
repetitively, and pointed to the bench where with other, not defendants but with families of the defendants
Mm-hmm.
was sitting. And
So basically, you're telling me that you were probably second or third person called because your last name starts with the letter B,
yes, that's fair.
and
That's fair to say.
and basically they started listening to your questions, and you completely pissed off the judge, and he didn't want the people behind you to hear what was happening, so he wanted to make you wait until the very end until he dealt with everybody else, and then he would finally hear you.
That is exactly what happened. He lost his temper very quickly and threatened to arrest me, threatened to hold me in contempt.
Why didn't he arrest you, by the way?
One more time, this is a special appearance. And even if it was a special appearance, still, since you're presumed innocent until you're proven guilty,
Mm-hmm.
and you are presumed innocent of all elements of the crime until you're proven guilty, and therefore you are presumed of jurisdiction,
Yeah.
which is one of the elements of the crime that needs to be proven
Beyond a reasonable doubt.
beyond a reasonable doubt with empirical evidence
Mm-hmm.
before you're I don't know you're
Before they have any standing.
yeah
Basically.
before they have any standing, before they have jurisdiction.
Mhm. So what did you learn today? I mean, I pretty much told you that you go in there, you ask a couple questions, and I knew from the get-go, this is Chicago, by the way, so it's probably one of the most corrupt cities in America, and I knew he was going to yell at you. I told you that from the get-go. I knew exactly what was going to happen, but I did not know how long was he yelling at you. For a few minutes, he just kept yelling.
For a couple of minutes more. Again, most of his responses were in a very aggravated voice, so he was pissed off. And those were very simple questions. Again, I didn't get past those three questions,
Mhm.
basically.
Okay, and earlier when you first told me what happened, you thought you had made a mistake. What do you think you actually did wrong?
Okay, well, let me tell you. Once everybody else went, all the other defendants' cases were heard in front of the judge.
Mhm.
I went at the end again, after waiting there for maybe like 3 hours or so,
Yeah.
and I didn't get any farther than the first time. This time the judge was trying to get me to say that I'm Vasily Becharov, and I kept insisting that I'm not Vasily Becharov, I'm Vasily, and I'm in no way to be mistaken for my legal title, Vasily Becharov,
Mhm.
or corporate entity, or whatever else. I'm Vasily. And that also pissed him off. He called me a prince, and said that I have no authority to assign myself a title, although I was just trying to properly present myself, and yeah.
Well, I mean, basically, I want everyone to know right now, this is not that sovereign citizen crap. This isn't that free man movement stupid crap that's going all over the place. People think they know what they're talking about. This is basically separating yourself from the fiction. This is they can only deal with a corporation. That's how they operate. They can only deal with a corporation. So when you separate yourself from that, he wasn't arrested because he was making a special appearance, not a general appearance. He was not appearing to be the corporation. So he made it very clear to the judge that he was not going to take the legal title, which is also, I don't care if it's uppercase, lowercase, it's the title of the corporation. So everything that he did it right. But I mean, it's what's that one thing though? What's that one thing that you told me I messed up? You know, I shouldn't have done
One
that.
thing at the end that I did wrong, or
That you think you did wrong.
I
What was
think I have done wrong,
it? Mm-hmm.
was that he asked me whether I want to proceed this to trial, and I said yes, without again probably thinking about for too long, and I should have thought of it for a little longer. And
That's fine. I mean, honestly, if you get in that instance where you think you messed up, you know, you accidentally give them an answer that they want to hear, that's fine because it's going to trial now, okay? Criminal court, okay? If if they can provide the evidence on this affidavit right here, then this guy is going to jail, which I typed the affidavit on myself. I've been doing this for a minute, so I'm pretty sure from my past experience that they're not going to be able to do anything about it. See, what I asked, oh, what did the judge say about the affidavit, by the way?
after reading the affidavit, the judge spent so much time typing up and revising.
Yeah, I revised like 4 times, yeah.
Judge ran through it. He didn't even read it until I got there. So when I was there, standing in front of him, he started going through the file and found the affidavit.
Mm-hmm.
So he ran through it, and then later on, at the end of the day, where I was there by myself, with nobody else present, without none of the other defendants present, he said it was nonsense and bullshit.
Hmm. Nonsense and bullshit
Nonsense and bullshit.
at the same time. Okay, well, in the affidavit, I had a list of presentments that must be refuted beyond a reasonable doubt or irrefutable. Yeah, this is irrefutable evidence that they're going to have to put up there. They're going to have to refute these presentments, okay? One of the presentments is that they have any evidence that the code, act, or statute that he's being charged with is even applicable to him. I made another one saying that the judge would have to put a signed and notarized affidavit on the public record saying that they have jurisdiction in the matter. My next one was basically the same thing, another affidavit signed and notarized on the public record under the penalty of perjury if he's lying on that document. That basically explaining how the judge being representing the state, which is an employee of the state, how it's not a conflict of interest if the plaintiff is the state. Um, and obviously the valid cause of action, the prosecutor needs to provide evidence of a valid cause of action, and that's how we impeach cops. I'm going under the Mark Stevens thing on that one. Any employee of the state of Illinois has to provide any evidence that he was in the plaintiff's state. Now, when they're talking about the state, they're not talking about the ground. I cannot stress that enough. They're talking about the body politic, built up of citizens. I've said this before, I'm not going to say it again. There is no such thing as a citizen. There can be no body politic. There is no such thing as a state. Okay? And, yeah, and we even gave them a back door under their own code that it says knowingly possessed the cannabis, but they have no evidence that he knew what was in it because it was a package. And yeah, and we basically we hit them with way too much stuff for them to even possibly come back. They cannot. They have to refute everything. They're not going to refute anything though. It's impossible. There is no victim. There is no crime. He literally did nothing. He had pieces of a plant in a box walking down the street. That was his crime. They're saying that somehow the state of Illinois, the plaintiff in the matter, the state of Illinois will suffer physical, financial, or property damage because of what he did. That they're saying that he did something. He didn't do anything. There was no harm at all. So we're going in here. We're going to. This is actually a motion to dismiss as well for no evidence of everything that I just said. But I mean, at the end of the day, I mean, when we started talking about this, you told me that you always knew that this was all BS, but it was a social norm because other people followed it. So you figured, oh, if the other
I
people are
didn't
following
know. I just that's the way I felt, and that's why I did have something in my possession,
it. Hmm.
and I acted according to the feeling where I'm not doing anything wrong. So why am I being prosecuted here in the first place?
Of course.
At least under why am I being prosecuted under the criminal code?
Well, what is the word? I mean, civil,
Civil,
criminal,
yeah, criminal meaning that you can go to prison or you can be punished with incarceration or even death in some states.
yeah.
And civil meaning that civil means a contract in Latin,
Civil is Latin for contract. Yes.
and money is the only recourse that the plaintiff can get from.
Yeah, he doesn't say by holding X amount of whatever that he damaged anything or that he hurt the state physically because it's a body politic. It's not a real thing. It's imaginary fiction. So it couldn't possibly physically be injured at all. It's not even claiming that, by the way. It's not going. The state is not going to pull up the records of its finances showing where he literally affected their finances in any way. What are they? They're saying that you violated one of their rules, and they're not even going to provide the evidence that those rules are even applicable to him. So, at the end of the day, Vasily, sir, you did legitimately piss off your first judge. So I congratulate you on that because there's a lot more to come. And yeah, you said yes, you want to proceed in the case, but look at it at the end of the day. Now the prosecution has to grant you complete disclosure in the matter. They have to show you everything they have, including all of these things that we posted up to them, all of these things in my presentments. They have to give him. If they do not have those things, then they have absolutely no standing in court. He is not going to plead. He is not going to sign anything. And if a judge tries to plead for him, like I told you earlier in my case for the criminal court in Alachua County, Florida, the judge entered an oral plea of not guilty. I should have. Now I know a little bit more. I'm not ever going to claim to know everything. But back in the day, I should have literally said, "Excuse me, if you would like to act as my power of attorney in this matter, can you please show me the contract that I signed granting me that authority over me? Because I personally do not wish for you to represent me in any way." But I mean, we'll see how this plays out. We'll keep you updated on it. We definitely this is exactly what I'm talking about, people. This man had the nerve to stand up for himself. He had the nerve to stand up for himself in a court of law. The judge would love nothing more than for him to come in with an attorney to screw him.
He made it perfectly clear that he would love to deal with another scumbag lawyer who would have violated my interests by giving me a poor representation, and I would have still I probably would have ended up paying thousands upon thousands of dollars and still getting fucked. Basically, still probably could have even done jail time or whatever.
Most likely would have done jail time.
Most likely jail time.
The best a lawyer will do if you have 3 years on your case or 5 years or whatever is they will lighten it, and you still have to pay the state and you still have to pay them. And when you get out, you have to pay probation because you're not just gonna get out and walk the streets. You have to pay probation as well. So yeah, at the end of the day, for anyone that's in a similar case, any possession, anything like that, anything without a victim at all, I want you to know this. Actually, just a quick.
And this applies across the board, not just Illinois, not just possession of.
Yeah, anything without a victim, anywhere in the world. Anything without a victim, anywhere in the world.
No victim, no crime.
Exactly. So if you have a similar thing, if you have a lawyer right now, if you were to ask him, is your obligation to me or the state or the country or whatever, the Commonwealth, it's not going to be to the person who hired the lawyer. It's going to be to whoever licensed the lawyer. That's where their obligation lies. So the state licensed the lawyers here. So if the state is the plaintiff, their obligation is to the plaintiff. So they will never, I mean, unless they're completely lying, which lawyers do. They don't tell the truth at all, so expect that. But I mean, if you do have these simple cases,
it's a joke. How do you know a lawyer is lying?
Go on.
His lips are moving.
Ah ha ha ha. Okay. Yeah.
See?
Yeah. Live audience. But no. Basically, yeah, that's the system we're living in. People they make up rules without victims, and then they charge you a buttload of money to pay them off. But yeah, I mean, do you have anything else to add to the matter right now?
Stand up for yourself. That's what you have to do.
It only gets bad when you don't
Do
stand.
not be intimidated by the years they throw at you. Just you have to do your homework basically, and you have to look up common law and the basic five things that that's the first when I waived my benefits in front of a judge and claimed my natural rights, which is what we were talking about earlier, the
Mhm.
common law. The only five things you can do wrong to, in order to be charged with a crime.
Mhm.
And if he knows that I know that he knows that everything else he's trying to throw at me is bullshit, and I couldn't have possibly done anything wrong, then don't be afraid of anything, and it's just an emotion.
Stand up for yourself. Handle your business.
Yes, yes.
Okay.
Find us, and we will help you.
It's people that stand up for themselves. We're going to start legal counseling in Chicago, Illinois. So if you're in Chicago, you're dealing with some issues, I will teach you self-defense in a courtroom. I will show you how it's manipulated so that you can never win if you play by their rules in their game in their courtroom.
Remember, this is just other people
Yeah, they're just people.
that you're dealing with, and they're not as smart as they would like to think they are. And the jury is also other people. And if again you can make it look like you are in the right, and I'm pretty sure you are in the right. Again, if you have not committed a crime that has a victim,
Mhm.
if you have not victimized anybody,
Yeah.
then
You're gold.
who'd you hurt?
Yeah, exactly. So, all right, everybody. This has been Free Thought Josh with Vasily over here. We are about to knock down some courthouses in a philosophical way, and this is Chicago. This is where I'm at right now. Anybody with any issues in Chicago, feel free to hit me up through this YouTube on Spreaker, anything. I want to get more clientele in here. I would like the system to be changed because this is one of the most corrupt cities in the country, and everyone here knows that. So, if you have any issues, hit me up. If anybody has any comments, anything they'd like to add to this, or any questions, go ahead and hit me up at freethoughtjosh@aol.com. Skype me at freethoughtjosh, and yeah, just hit me up on any website. I'm pretty much on everything. So, all right, everybody, take it easy.
Peace.